Hi, good morning. I want to thank the Sharia Council for inviting me to speak today. As you may know, the ACLU has partnered with a number of groups to fight many forms of religious discrimination against Muslims. In recent years, we've seen increased efforts to block Muslim groups from building mosques and Islamic centers. We've seen increased violence in the form of attacks on those worship places. We have seen Muslims denied entry to public buildings and discriminated against because of their religious garb. We have seen Muslims profiled and treated unfairly and unconstitutionally in the national security context. And most recently, we have seen a rash of proposed legislation across the country aimed at containing the so-called threat of Sharia law from infiltrating and taking over our judicial system, which is what I'm going to focus on today. Excuse me, I'm a little bit sick today. At the earlier panel, we received a very useful primer on the background and origin of these proposed laws. But I want to approach them from a different angle today by examining the claim that these laws are necessary. First, what are proponents of these measures talking about when they say that Sharia law is taking over our courts? Well, let's see if Representative Rex Duncan, one of the sponsors of Oklahoma's Save Our State Amendment, can shed some light on that. I'm going to play you a little video now, hopefully. Let's see. Okay. And just, I'm sorry, I can't seem to get this to play. Yeah, I'm clicking on it. Turn. Play.
The idea of Muslim law taking over in a place like Oklahoma where the wind comes sweeping down the plain makes seem pretty remote. So some state lawmakers there have decided it's time to make sure it never happens. They're hoping to get a question on the November ballot that would ask voters to decide if it should be illegal for state courts to consider anything but United States federal and state law when it comes to deciding cases. Republican Rex Duncan is one of the lawmakers backing the vote on the amendment that some call Save Our State. What do you want to save your state from?
Well, we want to save it from an attack on its survival, its future. Contested, Oklahomans recognize that America was founded on Judeo-Christian principles, and we're unapologetically grateful that God has blessed America and blessed Oklahoma. In State Question 755, the Save Our State Amendment is just a simple effort to ensure that our courts are not used to undermine these founding principles and turn Oklahoma into something that our founding fathers and our great-grandparents wouldn't recognize.
And do you believe that there's imminent danger of judges considering Sharia law when deciding cases?
It's not just a danger, it's a reality. Every day, liberals and
Okay, a reality. Wait, are you saying that, wait, has that happened in your state of Oklahoma that judges have? Okay.
It has not. This is a preemptive strike to make sure that liberal judges don't take the bench in an effort to use their position to undermine those founding principles and to consider international law or Sharia law. The other part of the state question is to prohibit all state courts from considering international law or Sharia law when deciding cases, even in cases of first impression. This will be an opportunity.
Well, I'm sorry, Mr. Duncan, but less than 1% of your state's population is Muslim, so where would that threat come from?
It's a growing threat, frankly, and this is a preemptive strike. They understand that this is a war for the survival of America. It's a cultural war, it's a social war, it's a war for the survival of our country. And other states, while they've looked away too long, looked the other way and kowtowed to political correctness, have lost an opportunity perhaps to save their state.
Okay, so now, setting aside the irony of a man who, in expressing concern that religious law is infiltrating our courts, suggests that the religious tenets of his faith should govern our country, you have to wonder after watching this clip, what could inspire such commitment to passing a law that marginalizes an entire faith in a state where there are literally no instances of this problem? The law's defenders have vehemently denied that they are prejudiced against Muslims. Along with my colleagues at the ACLU and at CARE, I represent the Muslim plaintiff in Oklahoma, and in that case, the state argued that the law was not singling out Islam, that it was not meant to discriminate against Sharia, that it was just an example of one of the many types of international law that courts could not apply. In other words, the state said, hey, we're not anti-Muslim, we're just xenophobic. Now, the Oklahoma law may well indeed be xenophobic, but it is also distinctly anti-Muslim, and the 10th Circuit Federal Court of Appeals agreed in striking it down earlier this year because it explicitly singles out Islam and Muslims for disfavorable and discriminatory treatment in the courts. Yet, these laws continue to be introduced in legislatures across the country. Last year, dozens were introduced. In the most recent legislative session, at least 20 states have considered them. So far, in addition to Oklahoma, Louisiana, Tennessee, Arizona, and South Dakota have actually passed some version of these laws. The more recent legislation has not been as bold in expressly identifying Islam as a target. They are more broadly targeted at religious law or international and foreign law. But the sponsors and proponents of these laws almost universally sell them at hearings and behind the scenes as necessary to deal with the threat of Sharia. So why do these claims persist? Is there something that we've all missed? Is there a latent Sharia threat to our judicial system lurking just below the surface that we've all been ignoring? Well, I don't want to scoop myself here, but I also don't want to keep you in suspense, so let me cut to the chase. The answer, I'm pleased to report, is no. There is definitely no risk of Sharia law overtaking our judicial system. These laws are a solution in search of a problem. And to prove it, last year the ACLU decided to dig deeper and examine in more detail the purported evidence offered by proponents of these laws. The result was a report entitled Nothing to Fear, Debunking the Mythical Sharia Threat to Our Judicial System, which I believe is in your packets and can also be accessed via the ACLU's website. At the time that we were putting together this report, the primary source support out there for the claim of the so-called Sharia threat, and one that we were asked about time and time again by legislators, was a document issued by the American Public Policy Alliance, which is one of a number of anti-Muslim groups along the lines of the Center for Security Policy. The document was called Representative Civil Legal Cases Involving Sharia Law, and it basically summarized court decisions from across the country that mentioned Islam or Sharia. But when we looked at these cases, all we found were garden variety claims that happened to be brought by Muslims, happened to involve matters of Islamic faith, or involve the civil law of a foreign country that happened to also incorporate some religious law. For example, the very first case cited by the APPA document was a federal district court case out of Illinois in which a Muslim prisoner had brought a lawsuit under the Free Exercise Clause of the First Amendment seeking a halal meal plan. In deciding the case, the court discussed what halal meant under the prisoner's religious beliefs. The case was hardly unusual. Prisoners of all faiths routinely bring lawsuits to protect their religious exercise rights. For example, the ACLU has defended the right of Jewish inmates to receive kosher meals. Here in Southern California, we've represented Sikh inmates who want to keep their beards in accordance with their religious beliefs. And we've represented or supported the rights of Christian inmates who want to preach the gospel or attend worship services. In the course of adjudicating all of these cases, courts must sometimes recount or examine the religious beliefs of the prisoners. Yet there have been no claims that those cases pose a threat to the integrity of the judicial system. There have been no concerns expressed that biblical law is overtaking our judicial system, notwithstanding the fact that there is a powerful, vocal, and organized segment of Christians in the United States that are seeking to effect that very result on a much broader basis. Other court decisions cited by the APPA document as evidence of the so-called Sharia threat included cases where Muslims had agreed to resolve their differences before a religious arbitration panel, and one party was seeking enforcement of that decision in court. Again, this is not unusual. People often contract in advance to allow an arbitrator to resolve their disputes, and sometimes they must seek enforcement of that decision in the state court. And in a number of those cases, the arbitration panels have, by agreement, been religious, which has included both Jewish and Christian arbitration panels. Provided that enforcing those decisions do not require the court to transgress the bounds of the Establishment Clause by delving improperly into ecclesiastical or doctrinal matters, or to enforce a decision that violates public policy, it is perfectly appropriate for a court to do this. Though it is true, as Marcy has told us, that there is a disagreement as to the boundaries of the Establishment Clause when applied in different situations, in the judicial context it is well understood that courts cannot take sides in theological debates and cannot insert themselves into ecclesiastical or religious disputes. So for a court to consider these type of arbitration cases is not improper in any way. Other cases relied on by the APPA document involved courts determining the validity of prenuptial agreements or marriages conducted overseas. The report also cited cases in which a court had to decide whether to recognize and enforce foreign judgments and court orders. These are all the types of matters that courts routinely handle. And our review of the cases pointed to by supporters of the anti-Sharia measures show time and time again that the courts in these cases treated lawsuits that are brought by Muslims or that address the Islamic faith in the same way that they deal with similar claims brought by people of other faiths or that involve no religion at all. But those pushing the anti-Sharia measures know that. And they know that because many of the very same court cases that they have pointed to as evidence of the so-called Sharia threat to our judicial system have actually resulted in judgments that they themselves would agree with. One case that the anti-Sharia law supporters love to point out is a New Jersey domestic violence case, MJR. A lower court had denied a restraining order against a Muslim man on the ground that his religious views pertaining to marriage caused him to lack the criminal intent necessary to commit the crime of sexual assault. What the anti-Muslim groups never mention is that a state court of appeals swiftly and unequivocally reversed and condemned that misguided decision as violating state public policy. In other words, the system worked. In another case cited in the APPA report, again, this is the report that listed all the cases that supposedly evince the Sharia threat to our judicial system. In another case, the Louisiana Supreme Court declined to enforce an Egyptian court's child custody order because Egyptian family law, which incorporates some elements of Islamic belief, did not require the Egyptian court to consider the child's best interest as paramount. The Louisiana Supreme Court determined that enforcing the court order would violate the state's public policy in favor of considering the best interest of the child. And remember that prisoner seeking the halal meal. The court in that case denied that claim and ruled that the prison's practice of serving pork-free meals was a sufficient accommodation. So these cases cited by the anti-Muslim groups in support of their claim that Sharia law is infiltrating our courts and taking over the judicial system can be considered evidence of that claim only if one believes that Muslims should be barred from asserting any claims at all in our courts. And when you look at their so-called evidence, that is the only conclusion that you can draw as to why lawmakers and others continue to support these measures. They are not offended by the thought of Sharia law threatening the very foundation of our judicial system because there is no threat. And even if there were the shadow of a problem, we have an amazing and resilient weapon in our arsenal to ensure that courts never become improperly involved in any faith, the Establishment Clause. Rather, because of their personal beliefs about Islam, supporters of the anti-Sharia laws are offended by the very idea that Muslims have access to the judicial system on the same terms as those of other faiths. And what better way to deny a member of a disfavored faith the fundamental right to religious liberty than by stripping their fundamental right to claim and defend that liberty in the courts? Or at the very least, as so many of the current versions of the law are intended to do, to send a message to followers of that faith, in this case Islam, that they are not welcome in the courts and should think twice before availing themselves of the judicial system. And that's why I think that events like today's conference are very important. One of the biggest challenges in continuing to defeat these measures is educating the public and legislators about what Sharia is, how our judicial system works, and the discriminatory aim and impact of these laws. And I think that this conference today is going to go a long way towards doing that, especially since these panels are going to be available online. And I thank the Sharia Council for inviting me to be part of it.